Hi guys, this is Erica from Gokce Capital.
Now before I begin, be sure to subscribe to our YouTube channel and turn on notifications. In New York City, there is a small section of the zoning ordinance that has become the bane of many a Manhattan infill development. The law was created in the 1980s and is designed to prevent very tall buildings on narrow lots. It was the result of a change in 1977 to the zoning ordinance that allowed the transfer of unused development rights from one property to its neighbor. The result was a number of very tall, very slender buildings called slivers. The most famous of these buildings is Morgan Court, also known as the Sliver Building, pictured here. Its fame was guaranteed when it became the location of the movie Sliver, that was named after Morgan Court, or the Sliver Building. In response to buildings like Morgan Court, the zoning ordinance was further amended in the 1980s to include a small provision known as the Sliver Law. This provision states that buildings built on lots that are 45 feet in width or less cannot be taller than the width of the street in front of the property or the neighboring properties. Since its creation, the Sliver Law has killed a number of proposed infill development projects, and in some cases, even completed projects, including one case that involved the East Village's most notorious landlord and a disappearing penthouse. I'll cover this story later, but in today's video we're going to cover the top things you should know about land development so you don't run afoul of laws like the Sliver Law. Number 1. Entitlement is the process by which you gain the legal right to develop a property in a specific way. Another way of putting this is that entitled land is land that has all required government agency permissions to be developed for a specific use. Prior to going through the entitlement process, there is a lot more uncertainty about whether a specific building can be developed. Number 2. The entitlement process involves a number of steps. The exact steps that you will need to go through for your development project will vary depending on the jurisdiction and the project you have in mind. Projects that require variances or exemptions to existing regulations are going to have a much more extensive entitlement process versus projects that are being developed as of right and are in compliance with all existing rules and regulations. But some of the most common items that you will need to go through as part of the entitlement process may include a rezoning, in the event that you are proposing a use that is different from what is currently allowed on the property. A zoning variance. This may be required if you are developing a use that is allowed under the zoning ordinance, but you need a variance from some other aspect of the zoning code, such as an exemption from a height restriction or a certain setback requirement. Environmental review. In many jurisdictions, if you are requesting any kind of discretionary action, such as a rezoning or a variance, you will need to go through a full environmental review process, including submitting an environmental impact statement. In some jurisdictions, regardless of whether you are asking for a rezoning or a variance, you will still need to get a zoning or use permit. Even if you don't, in almost every jurisdiction, you will need to apply for a building permit. And you will need to get approval from all utility providers in order to connect to any existing public utilities. If there are not public utilities available, you will either need to work with the utility provider to extend utilities out to the property, or you will need to get the relevant approvals in order to install a septic system and/or a well. And you may also need to get approval if you are developing out a road to the property, or if you are creating a new driveway or new subdivision roads. As you can tell from all of the steps involved, land entitlement is a multi-step process and can take a very long time. The exact steps vary from jurisdiction to jurisdiction and from project to project, so in this video I can only give you a very general overview, but it's a good idea to speak with a local land use attorney or real estate consultant, as well as your architect and engineer, to go over all the steps that will be required for your project. At a high level, you will first want to review all building and zoning regulations as well as local laws, and discuss with your consultants to ensure that your project complies with all regulations. You will then submit a proposal to all relevant agencies. Now, generally, you'll start with the planning department, especially if you are asking for a discretionary action like a zoning variance. Around the same time, you will begin undertaking all required tests. These include the tests that will be required by the agencies involved in order to issue any required permits, but these could also involve any tests that you will be doing for your own due diligence purposes, like environmental site assessments, perk tests, surveys, geotechnical tests, etc. And once you have all required documents and tests, you will then submit a full packaged to the relevant agencies and have the project reviewed by the agency. Now keep in mind that certain actions, such as a rezoning or a variance, will also require public review and a public comment period. Now, one of the most important things to keep in mind about the land entitlement process is that it is often delayed. As we've seen, the process typically involves many different agencies and so can take months to years. But because there are going to be so many parties involved, there is a high likelihood that at least one step of the process is going to be delayed for any number of reasons, including an initial rejection by a particular agency, an unexpected condition coming up, or, as is the bane of many development projects, the laws changing over the course of the entitlement process. So when you are planning out your land entitlement process, plan for delays and don't try to adhere to an overly optimistic schedule, especially when you are thinking about financing and cash outflows. Number 5, the entitlement process can be very frustrating, so you'll want to go into it with a clear plan. The most important thing you can do is put together a team of experts that know the local jurisdiction and understand how to get your project entitled. So think about who you need on your team to make the process successful. At a minimum, you will need an architect and an engineer, but you will also likely need an environmental consultant, perhaps an experienced project management consultant or real estate development consultant, and a good land use or zoning lawyer. Also know ahead of time what exceptions you will be seeking for your project and what this will mean for the entitlement process in your timeline. The more exceptions that you will be seeking, the longer you can expect the entitlement process to be, and the more uncertainty there will be regarding its success. Once you know what kind of exceptions you will be seeking, then you can plan out all the approvals that you will need to obtain before your land is fully entitled. When you know what approvals you will need, you can then think about all the different tests, inspections, and work products that you will need to produce in order to seek approval from the relevant agency. And as you are thinking about all of this, always keep Murphy's Law in mind. What can go wrong shall go wrong. Think about all the potential negative surprises that can arise through the process. If you're doing an environmental site assessment, what happens if contamination shows up? If you need public approvals, what if the local public official will not support your project or wants it to be smaller? Plan ahead and be prepared for the worst. So what happens if you don't follow all the proper entitlement processes? Well, you may end up having to demolish your work. Let's return to the Sliver Law. In 2006, the owner of 5151 East 5th Street, a notorious East Village developer, self-certified a permit to add a 6th-story and penthouse addition to the building. The owner self-certified under the assumption that a penthouse would not be considered additional height to the building under the Sliver Law. Residents of nearby buildings appealed to the Board of Standards and Appeals, or the BSA. Eventually, the BSA ruled that the Sliver Law applied to penthouses. The building owner asked for an exemption from this ruling because the penthouse was already complete, but the BSA rejected this request. The result? The penthouse was demolished, of course, at the owner's expense. Now, do you have any stories about land entitlement? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down properties at gokcecapital.com/listings. Finally, don't hesitate to reach out with any questions. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.